Revolution on AKBC Channel 45. Pathfinder AM45, making your Monday morning worthwhile.
So good to know you are still there. It's still a worthwhile Monday morning if you ask me, because you're watching Pathfinder on AKBC television. And the reason we are always here is to educate, inform, and entertain you. And right now on this particular segment, which is the law segment, we are here to educate you on something that you need to know. You know, there's so many people that don't know that they have legal rights in the society. And so their rights are always being trampled upon, either by family members, or friends, or extended family members, whoever it is that is involved in your life. The reason some people fail is because they don't do one particular thing. What am I talking about? I am talking about will. I'm sure you've been hearing that someone have written a will, or you watch movies most times where you see a will is being written, and then if the person died and the family members come out to deliberate and read the will, a lot of people will get offended and they will get to challenge the will and all that. What is will, and what is really wrong with will, or what is right with will? We are going to hear that today. To talk will today with me is someone who has the opportunity, by the grace of God, has gone to school, and he is an expert in that field. And so when you bring an expert in a particular field to talk about something, you know that the person has an authority. Join me as I welcome Barrister Clement Imo on Pathfinder this morning to talk will with me. Good morning, Barrister.
Good morning. Thank you. It's a pleasure to be here.
It's a pleasure to have you on Pathfinder.
Pleasure is mine.
Okay, so how was your weekend? How has it been?
Well, it was great. It was eventful, but unfortunately, it was very short and now it's over.
Oh, really? I'm sure the reason is what you can explain if you asked. But all the way, I'm sure you since you are alive and you are here today, we thank God for life.
Oh, yes.
So I just say that for people to talk as an authority in a particular field, you have to be vested with what you talk about, right?
That's
so
right.
before you talk about will, let's get to know, we call you barrister. What makes someone qualified to talk about a particular legal issues?
Well, first of all, before you can even ascribe to yourself the title of barrister, you must have gone through 5 years of rigorous legal training.
Okay.
For starter. Okay. Now, when you're done with that, you don't have to proceed. Now, that's in university, the 5 years, where you learn everything about the laws in terms of statute books, what the law is, what the law says. Now, when you're done with that, you now proceed to the Nigerian Law School, that's if you want to practice in Nigeria, where you now learn the ropes of the procedure. Not just knowing what it is, but you now learn how to apply it, and you learn how it works. So now you have the knowledge, and then you know how to apply it. So a minimum of 6 years, if strike does not catch up with you.
That's only if. And so that, but some people do go to school and they are not being called. Must you be called to bar before you're qualified to talk law?
Well, the law in Nigeria is that for you to practice law, you must have been called to the bar.
Okay.
Yes.
All right.
You cannot practice without being called.
Okay. So if we hear any particular person who had opportunity to go to school and study law, and maybe unfortunately or some circumstances he or she is not called to bar, such person cannot be termed as an authority to talk law.
No, I wouldn't say so.
Okay.
Yes.
All right.
Because it's the call to bar that gives you the license to practice. So no matter what you know, no matter what you have learned in school, you cannot practice except you have the license.
Thank you for answering that question. Now let's go straight to the business of the day. What is will?
A will. A will is a document made by someone to determine how his property would be dissipated after he passes on. You know, one thing is certain, nobody, all of us is going to be in this earth forever. And we all have one item or the other that we have acquired over time that we hold dear to our heart. So a will is that document that helps you decide on how you want this thing to pass on. What do you give to who gets what, and who takes what, and when. That's what a will does.
That's a will. It has to be a written document.
In most instances, it has to be written, but the general concept in law is that there are exceptions. But the general principle of a will is that it has to be written down.
Okay. Now let's talk about why it is important. Since it has to be written down, why must someone write a will?
Now, the importance of a will cannot and can never be overemphasized. Because when anyone passes away from this life, when I pass away, when you go to meet your maker, we would have left some things behind, and we want to be sure that these things are shared out to the people we love the way we want them to be shared out. For instance, I have 2 phones, I have a laptop, I have a car, I have a pair of suits and a pair of shoes. And I want my first son to have my suit, I want my daughter to have my wristwatch, and maybe my second son who is studying law, I want him to have my wig and gown. Okay. Now, where there is a will, I can comfortably and conveniently write all those things down the way I want my properties to be dissipated and be very clear on it. But where there is no will, I will not be able to achieve that, because things will just go in any haphazard manner, because there is no clear direction on what should be done when I'm no more.
Okay. You've answered why will is important, and I think I was just trying to attempt the types of will. So let's go straight to the question now. The types of wills we have. Types
of will. Now, because we're in Nigeria, I'm going to attack the question from the standpoint of the Nigerian legal system. Now, under the Nigerian legal system, we have basically 3 types of will. We have the statutory will, we have the other one we call the non-cupative will, and we have a third one which we refer to as the privilege will.
So you're going to explain those wills, what they
You want me to explain?
Yes,
okay, I'll go
what they
ahead
stand
and
for.
explain. Now, the statutory will is the will that is made according to statutory requirements, according to what the law says. It meets all the requirements of the law. Number one is that it is written down. Another requirement is that there must be witnesses. Another requirement of the law, when it has to do with making a will, is that the person must have the capacity and testamentary capacity, and also have clear intent of making the will. A statutory will, therefore, is a will that meets all the requirements of the law in terms of how a will should be made.
Okay.
Yes. Now, should I go on?
No, you explain the 3.
Okay.
The essence of listening to you is to learn, and so that when someone wants to get involved in real issues, we know exactly. Yes. Remember when I introduced the program, I said that so many of us will have issues when we don't know our legal rights.
That's correct. Okay, now the second one is the one I call the non-cupative will. Now, what do we mean by non-cupative will? It's a will that is made but that does not exactly meet all the formal requirements of the will as provided for in the statutes. For example, one of the requirements of a will is that it must be written down. But there are instances where someone passes away without having the opportunity to write down his desires, but he mentions it orally. For example, our loved ones who are in the more remote areas, in the villages, I mean, I'm sure when my grandfather passed away, he never thought about anything like a will. Or maybe on his dying bed, he must have had his kinsmen, brothers, sisters, family members around, and they will say, please, that particular plot of land opposite the market square, give it to my first son. The other one down by the river, let it be given to the second son. Now, you see, in this particular scenario, he orally makes his declarations, but they are not written down.
Okay. But
there is still some fundamental parts that has been met, and that is the fact that, number one, he must be seen to have the mental capacity to make the will. If he's beginning to go paranoid, he's losing his mind, you cannot say that is a will, because whatever he says will not be held very accountable. And number 2 requirement is the fact that there must be credible witnesses. So these must be people who can be able to repeat what he has said, and they must be credible enough for people to believe that what they say is actually true. So that's the second one, non-cupative will.
Okay.
Now the third one, which I mentioned under the Nigerian law, is the one we call the privilege will. Now privilege will, it applies specifically to members of the armed forces or other security agencies who for some reason are not able to meet the requirements of a formal will in terms of writing and the presence of witnesses and all of that. The law allows them, because of the nature of their job and the level of exposure, the law presumes that they might not have the privilege and opportunity to call a lawyer, to call witnesses, to call credible people and say, I'm about to make a will. But then they are allowed to make statements as to how their estate and property should dissipate, maybe amongst their family members, loved ones, or persons they care about.
Okay.
And this will be regarded as a will under the caption of a privilege will. Those are basically the 3 we have under the Nigerian
So we've heard the explanation of the 3, and if you will put more light on it, we'd love to know the three are not valid will. I have heard you mentioning the fact that if the person just mentioned something verbally and it was not written down, at some point it cannot be honored. It must be written down. Now let's talk about the validity of a will. What makes a will valid?
Now, for a will to be valid, it must meet the specific requirements of a will. Number one is that, let's talk about statutory wills. Now let's focus on statutory wills with regards to validity of wills. Number one is that it must have been written down. Okay. Number two is that the maker must have testamentary capacity. He must have the ability to make a will. For example, someone is in a dire medical condition, maybe he's hallucinating, he begins to call red white, he sees one person, he says he's seeing three people. There's a fear that he's losing his mind. So someone in that state cannot be said to have the testamentary capacity to make a will, because he will be regarded as being of unsound mind. When it happens like that, he loses the capacity, and anything he does in the name of a will ends up being, to an extent, invalid, or can be invalidated. Okay. Another one is that there must be witnesses for a statutory will. It's not enough to just say, oh, this should happen, that should happen. People must be there to witness it. Okay, so even if it's written down, people must be there to say, when this man made this will, I was there, and I was sure that he had the right mental state, and he intended to make a will, which is a third condition. Okay. That is a clear intent of making a will. When I'm writing a will, I should have the intention that I'm actually making a will. If you give me a piece of paper now and tell me, barrister, please just sign this document for me, it's a land document, and I end up signing it unknown to me that it is a will or it is my will, that will not be a valid will, because at that point in time I didn't have the intention of making a will. Okay. I didn't know that what I was signing was a will. So these are some of the things that would make a will valid or invalid. It makes the will valid when they exist, and can make a will invalid when they do not exist.
Okay, now we're talking about the validity, because this is where the main emphasis will be. Still talking about that, you know that some people do create a will, or you mentioned someone can be conscious or unconscious while writing a will, or sometimes someone can be under duress, being forced by a particular person, a member of the family with evil intention to write a will. Let's talk a little about that.
Okay. Now, when we talk about things that make a will valid, number one, amongst other ones, like you've mentioned, there must be no form of compulsion, duress, or due influence. Excuse me. Yeah. It must be seen that the person made the will free willingly, knowing that what he's going into is his will. If a man puts a gun to my head and tells me to make a will, sign this or sign that, and claiming that he wants me to do it and he wants me to do it now, that cannot be said to be a will, because it will now mean that I have lost my free will, I've lost my voluntariness, and then it cannot exactly be held as an actual will, because tomorrow I'd wake up and say, I never made that will, this is not what I intended, this is not what I want, in fact I completely distance myself away from it. So it must be seen that there is no duress and there is no undue influence. So these are some of the very important factors one will consider when making a will. And that's not all. It must also be seen that undue influence can take several perspectives. It can be someone threatening to do something to me, maybe a sort of harm or danger. It can also be someone depriving me of a privilege. For example, let's assume there is a certain big man in quote that I need a favor from, or I'm supposed to get something from, maybe a promotion. Okay, good example. In my place of work, I'm supposed to get a promotion, and then the man comes up and says, Oga Barrister, if you don't write a will that says you are giving that your plot of land at AK Market to my first son, I'm not going to allow you to get promotion in this work. And I say, please sir, Oga say, lie, you must do what I want. And I end up writing it that way to make him happy. He has compelled me. That amounts to undue influence, because he's now telling me that he will deny me a privilege that is due to me. So that is undue influence. Okay. That's one side to it. Then the other side is someone threatening harm. For instance, like I mentioned earlier on, someone putting a gun to my head and saying, sign this and write that. That's under
duress. That's when it is forceful.
Yes.
Okay, so if someone didn't witness it, for example, someone forcefully asks you the lawyer, the barrister, to write a will, and it's between you and the person. Maybe some other people that were there, 2 or 3, like he said, people that were helping him in the acts of perpetuating that evil act, and then you are being forced as a lawyer to put down that will because that's what he wanted. Or sometimes it could be, let's bring a stepmother in, because some stepmothers could be very funny, you know. Maybe they know that the husband is going to die soon, and they don't want the other children, especially if there are more male children on the other side, and then it's under duress. Someone come with some armed men and force you to forcefully write and sign a will that was not written. Remember, the man is sick and can't even do anything. Now, what would you as a barrister do when a situation comes, when it is time to read the will between the members of the family? Remember, you're being forced to put such thing down.
Okay. Now, you are saying that I am being forced as a lawyer to
by
write
that
the
member
will.
of the family to sign that will. It may not be you that writes it, it's just your signature. And if your signature is in it, that means you wrote it, right?
No, actually, let's get it clear. A will is made by the person who owns the property.
At this point, someone comes with a will, and like I said, the second wife, and told you that the husband have written this will.
Yes.
Just what you need to do is to sign.
No, that would not be valid.
Okay.
It will not be valid because it's not the lawyer's signature that is important in a will.
Okay.
It is the man who has property to dissipate. So, if let's use an example, Mr. Akpan. Mr. Akpan must be the one to make the will, and he must make it and then sign it as his will in the presence of 2 witnesses.
Okay.
More often than not, most people would like their lawyers to be there, which adds a sense of
as a
validity
witness when the will is being written, right?
Yes.
Okay.
In most instances, a lot of people even have their lawyers write the will for them. Write the will for them in the sense of this is what I want. So he writes it on a piece of paper, gives it to the lawyer. Lawyer goes and formalizes the write-up, make it look like a standard legal document.
Okay.
When he's done with it, he brings it back to Mr. Akpan. Akpan looks at it. He agrees that this is what he wants. So he signs it as his will in the presence of 2 witnesses.
Okay.
So that's what gives it a validity. It's not enough for somebody to bring in something from anywhere and come and tell me, oh, barrister, you know that your client, Mr. Akpan, you know I'm his second wife now. He gave me this will, so I should come and give you. Please, barrister, carry and keep. No. Okay. The barrister must carry out due diligence to reach out to Mr. Akpan and be sure that he actually made that will. When he cannot do that, then the barrister cannot vouch for the validity of that will. That will amount to fraud if he does so.
That's good to know. So in a process of trying to establish such a will, and the barrister, the lawyer, knows that will is not valid, but because he was under duress to sign, like I said, and then it is time to read it in the members of the family, and some members of the family say they are not okay with it, right?
Yes. Okay.
Something can be done about it.
Definitely something can be done. Now,
okay.
A lawyer has a duty, a fiduciary duty to his client. That's a duty of trust. At all points in time, a lawyer must maintain his client's trust. So, even in circumstances where, like you have explained, the lawyer is made to accept that document as emanating from his client, even though under fraud, a lawyer has a duty, first, to preserve his life. So he might willingly accept to do the will of those people because they are pointing a gun to his head. It's allowed for a lawyer to say, okay, I've heard you, I'll do it. But the moment they go away and leave him, a lawyer has a duty to report such acts to law enforcement. He can call the police immediately and say, this is the situation on ground. There is a fraud going on. My life is at stake. My life is in danger. Please come and rescue me. The lawyer has that duty to save himself and then save the estate at the same time. The lawyer cannot hide under the guise of, oh, I was threatened, my life was at stake, my life was in danger, and then continue in that fraud and illegality, going into the family compound and reading out that will, claiming that that was the will of the man. That would be completely wrong. He must at some point in time put an end to that illegality, put an end to that fraud.
Okay. Sorry about that. The weather and everything is affecting me. That's why
it's the rainy season.
I'm sure my viewer will bear with me. Please just understand with me. It has to do with the weather. That's what I'm feeling at the moment. Thank you for your understanding. Now you've talked about it. Now what happened if Mr. Akpan, let's use that name because you brought the example. Mr. Akpan died without writing any will, and there are members of the family, maybe like extended family, or maybe some people in polygamous family. There's no will. The man has so many properties. Eventually, something happened with accident or sickness. Mr. Pan dies, and then without writing a will. How can such family members distribute or share the properties among themselves?
Okay. Now, if Mr. Pan is to die without a will, it means that the property will not be shared in the exact way he would have wanted or desired. What then happens is that the property will be shared according to the provisions of the state law. We are currently in Akwa Ibom, so let's use Akwa Ibom as a classical example. And in most states across the federation, it provides a certain formula for sharing of properties, and it will be according to what is inside the law. We have the Administration of Estate Law of several states that provides on the formula on how things should dissipate. And more often than not, it starts with the surviving spouse.
Okay.
If it's Mr. Pan that dies, his wife is first in line to inherit his property.
Okay.
After her is the children. After the children, you now have parents of Mr. Akpan. After parents of Mr. Akpan, you have siblings of Mr. Akpan, his brothers, his sisters. It's when that one has been exhausted, you now begin to go to other extended family members like uncles, aunties, and the like. So, Mr. Akpan dies, the wife. If Mr. Akpan's wife has died earlier, then the children, or let's assume, unfortunately, Mr. Akpan and the wife die in a motor crash. Two of them died together, so the wife is not available. The children automatically are next in line in terms of what the law says. And if for a very fortunate circumstance they were all traveling together, Mr. Akpan, the wife, and all of the children, then the next person, number 3 on the category, is going to be Mr. Akpan's parents. Okay. Now I'll give an example of how this played out very recently. I think it was last year when Herbert Wigwe passed on.
Okay.
You know, Herbert Wigwe passed on with the wife. I think he did pass on with the wife.
Is that the story of the accident victim? Is that the one you mean?
Yes, the man, the Access Bank, who crashed in that helicopter.
Yes.
I think he passed on with the wife, if I'm not mistaken.
Yeah.
Let me not say for certain. But when he passed on, the wife was not available because she was no longer alive. She would have been first in line to inherit the property and the estate, but she was not available. So the next person in line is the child. Okay, that's what the law says. But you see that because there was no will.
Is it just a child? Can it be a female or a male, or just a child?
Under the law, child is child.
Child, even if it's a female, is a first child.
Yes, child.
Under the law, is a child, not male or female.
No, law doesn't specify gender.
Okay.
Just let me say the children.
The children.
The children will take over the estate.
Okay.
Now, where the children are not available, then the parents of the deceased person. But you know the danger of all of this is that there might be some wahala and struggle among family members. Like we saw in the family of Wigwe, his father was saying, I should be the one to take over the property. The daughter said, no, I'm the daughter. I should be the one to inherit my father's property. And then they ended up in court and it ended up looking so messy. So these are the dangers of not having a will, and that's how the succession plan always goes, because it's what the law says according to the laws of each state.
Okay, so that is why will is important.
Very important.
Because it will help to create harmony among family members. If unfortunately the deceased, someone is deceased and the person was writing it will down.
That's correct.
Now let's talk about this will. If at all there was a particular will, remember I brought an example of someone being forced to write a will, and then some family members come and say they're not okay with the will. Now the question is, can a will be contested?
Yes, and yes, the will can be contested. It can be contested on several grounds. Where the family members feel that the wordings of the will do not exactly represent what their loved one who has passed away would have wanted. For example, some people, even before passing on or before even writing a will, they discuss among their family members. Someone will tell the child, see, my son, when I pass away, bury me under that coconut tree. Don't let them take my body to a cemetery. My second son, you will take care of that business we are handling in Lagos. Akpan, you will be in charge of the business in Abuja. So the man is already singing these things to the children and family members. All of a sudden he passes away. Papa never told them he was making a will.
Okay.
Then somebody comes out of nowhere and says, this is Papa's will, and says that everything he has should be given to his stepbrother, who has never seen him in the past, who he has not seen in the past 10 years. the family has a reason to suspect that there is fraud. It can be contested on that ground. Another grounds upon which a will can be contested is if there is any doubt as to the validity of the will. Remember earlier on we talked about things that will make a will valid. It must be written, testamentary capacity, okay, the person must have had the intent of making the will, there must have been credible witnesses. If for instance, Mr. Akpan, let's say a year before he passed on, lost his mental capacity, he was having hallucinations, was going through mental what's the word? He was delusional.
Yeah, maybe he's having a mental problem.
Yes.
You know, in our society, when we hear someone have a mental problem, we only attribute it to madness.
Yes.
But there's studies that show that when we talk about mental illness, it can be a lot of things.
Yeah,
just
very broad spectrum.
Yeah, very broad.
If Mr. Akpan had some level of mental incapacity known to the family for about a period of 1 year, and then he suddenly passes away, and somebody comes out from nowhere and says, "Oh, Mr. Akpan made a will 3 months ago," the family would raise up a protest against such a will and say, "No, our father, God rest his soul, has had loss of mental capacity for over a period of 1 year. This is the report from the doctor, so he could not have made this will." Okay, so now they are attacking the validity of the will. Another instance where they can seem to attack the validity of the will is where the family members were not parties to the will, they were not brought in as witnesses, and then somebody from nowhere comes up and says, "Your father made a will, and in that will he gave you people 50% of his estate and gave me 50%.
Okay.
He dropped the will with me. I was the witness, I was the only witness." That raises suspicion. So they can question the will in that regard. Another one again is when there are no credible witnesses. For example, people who come up as witnesses to the will are people who let's say 2 people, let's say John and Silas, and the community know these people, that these people are pathetic liars. They can never be seen in anywhere that they're speaking the truth. They are always involved in one dubious thing or the other. Then you now bring those people to come forward and say, "Oh, Papa made a will, oh, we were the 2 witnesses." People will find, especially when the family members listen to the content of that will and it doesn't sound like what their father would have wanted.
Okay.
Especially if he has been a man who has been singing to them. They can question the validity of that will because of the questionable character of the supposed witnesses. So a lot of things can be reasons for a will to be contested in terms of validity.
That's good to hear. So it's just sharing information about what we need to know about a will. If you're just joining us or tuning onto your television set, you're watching Pathfinder on AKBC television. And right here we are talking about will. This will is actually very broad. We cannot exhaust all the questions you have about will. Let's just say by God's grace we have to do justice to this will again some other time. But for now, we'll also give you an opportunity to ask questions. Remember, we've talked about what is a will, what makes a will valid, can a will be contested, and at what point should it be. So if you have any question now you want to ask the barrister here in the studio, there's going to be a phone number on the screen. Just call us and be part of the discussion because that's why we are here. We cannot just do this just telling you without you. I'm sure there's so many questions you want to ask. So as I said, we have a lot of questions that we want. We cannot really exhaust them here. But let's get to know if someone has written a will. No, Mr. Pan, let's just stay with Mr. Pan.
Yeah,
Mr. Pan has written a will, and maybe 2-3 years later, Mr. Pan feel what he has written is all right, or something happened, he has changed his mind, and he wants to change the will. How does that go?
Yes, a will can be modified.
Modified.
It can be modified, it can be updated, it can be changed, it can be completely abandoned. Okay, and it is done through a document known as a codicil.
Codicil.
Yes, a codicil. It's a document that seeks to amend a will. So if, for instance, like you have said, Mr. Akpan wakes up and it's like, why did I even make this kind of will and give so much to this person and this person who has almost nothing? Let me change it. Okay, that can be a reason to modify the will. He calls up his lawyer, they draw up a codicil, and the will becomes updated. Another reason might be, maybe at the time Mr. Akpan made the will, he had 2 houses. But now, Mr. Akpan has gone into politics, he's now a former commissioner, a former this, former that, has amassed so much more wealth over time, has more properties. Then there is need to allow the will to reflect these new properties Mr. Akpan has acquired over the last few years. He can therefore modify the will,
Okay.
updating it still using the same document known as the codicil.
Under what circumstances can the codicil not be honored?
A codicil, like I already mentioned, is a document that seeks to amend the will.
Yeah.
It must also follow the process of validity of a will. So, all the requirements for a valid will must exist in a codicil. Number one, he must have testamentary capacity. He must be of sound mind. He must not have any form of mental ailments. Okay, he must have a clear intent that he wants to make a document to amend the will. If Mrs. Barry, somebody else brings a document to you and says, "Oh, Mr. Akpan, sign this document for me. Let me sell my land to you." Unknown to Mr. Akpan that what he's signing is an amendment of his will, giving all his property to this person who has given him the document to sign. That will not amount to a codicil because there is no clear intent on it. Another one is you must also have the presence of credible witnesses to witness to the making of that document. Like I said, the only thing that makes a codicil different from a will is the name. It is all the requirements are the same. What it talks about is the same because it relates to how Mr. Akpan's property will be dissipated after he is gone.
Okay, how about if the codicil does not really have the contents of what the former will was? For example, while Mr. Akpan has written his first will, he has willed some properties to this, and the names were there. But looking at the codicil, all those have changed.
Well, the law is trite that a man is allowed to do with his property and his items the way he wants. Okay, so if, for example, Mr. Akpan had 17 properties in his will and talked about 17 things, give this one to this person, give this one to that person, you know, and then comes up tomorrow and says, "Oh, I want to make a codicil, I want to change this, I want to change that," and then instead of adjusting the 17 properties, he touches on only, let's say, 7 or 5 and abandons the other ones. It doesn't in itself make the codicil invalid, not at all. The codicil still remains valid, okay? Just that now Mr. Akpan has found reasons to limit his will from initial 17 properties to now 7 properties. And like I said earlier on, Mr. Akpan has the full discretion. He doesn't owe anybody an apology or an explanation on how he dissipates his property or how he intends to share his property amongst his loved ones or anybody. Okay, so if the new document now, the codicil, talks about only 7, omits the other 10, nobody can question Mr. Akpan. The only thing is that when Mr. Akpan passes away and we now want to read this document, we are not going to say, okay, because this new one, codicil, talks about only 7, the other 10 are not captured. Let us go to the previous, the first will he made and cover everything. No. The moment a codicil is made, the initial will becomes invalidated. It becomes a worthless piece of paper. Okay. So what will now happen is that Mr. Akpan now has a will, a will modified by a codicil that is limited to only 7 properties. Okay. This is a very interesting part because now Mr. Akpan is in a dilemma. 7 properties are covered by the will. 10 properties are not covered by the will. So those 10 properties not covered by the will be treated as though Mr. Akpan does not have a will at all. Okay. So they'll be treated in 2 different parts. That's what is going to happen in Mr. Akpan's scenario. Okay.
So this particular codicil, at what point can codicil be suspicious?
A codicil will be suspicious in the same way as a will be suspicious.
What are the contents? What will happen if, for example, the family member open and see the codicil and read the codicil? Because when you look at the codicil, you have to compare a lot of things. Maybe the signature, maybe the write-up. Like I said, maybe in the former will, Mr. Akpan has willed some things to some member of the family, and you know strongly that is what Mr. Akpan would have wanted. But in the codicil, such things are changed, and then try to look at other things surrounding it. What are the things that if you discover in the codicil that are not the same? For example, if you're a son or a daughter to Mr. Akpan or a family member, you know that this is not what my father or my husband or my brother would have written.
Now that's where it becomes a bit dicey and tricky, because like they say, nobody knows the intent of the heart of a man. A man in generic form now, meaning both man and woman. A man can be looking at you, a man can sit down and be smiling with all his children, his wife, and say, "Don't worry, my children, when I'm gone, whatever I have, all I have is yours." Unknown to them that there is a second wife somewhere in another city with her own children. This man might be laughing with these people and say, "Don't worry, everything I have is all yours." And then the man wakes up one morning and the other wife treats him better, he begins to love that one more and her children more, and decides to will almost everything to those other people, neglecting these ones. Now, these other people will feel unhappy, they will feel aggrieved, they will feel sad, and they might want to challenge the will and say, no, our father loved us a lot, he could not have done this to us, this should be a fraud. But then, it is nobody's place to know the validity of the will in terms of the content. It's not the content that makes a will valid. I need to repeat that. It is not the content of the will that makes it valid. No. The validity is in terms of the surrounding circumstances.
Okay.
Did he have the mental capacity to make the will?
Okay.
Were they the required number of witnesses?
Okay.
Did he follow the requirements of statutes? For instance, a man can wake up and decide to will his entire property to a church, or even say, okay, I want to will my property to a goat. It sounds absurd, especially if that man has lots of children and let's say 4 wives. But then they cannot begin to say the will is invalid because he willed everything to a goat or to a dog or to a horse.
Okay.
Because that doesn't make it invalid. But that's the content. What is looked at in terms of validity is the circumstances surrounding the will. Did he have the mental capacity? Was there any influence? Was there any duress on him to make that will? Do you have credible witnesses? Is it written down? All the other requirements for making a will, are they there? Once those things exist, I'm sorry, even if Papa decided to neglect all of you and will all his property to a church that prophesied for him 2 days ago, that will be looked at as valid in the eyes of the law.
Oh, really? Okay, that's good to know. Now, at this point, is it possible for a will to be doctored?
Yes, it is.
So what happens to a doctored will?
A doctored will, where it is proven that this will is doctored, which means it is manipulated,
yes,
that will becomes invalid.
Even the codicil too?
Yes. Now, if there is a codicil and it is proved that this codicil is manipulated, it's a product of fraud, the codicil would cease to exist, and then it will be as though it never happened, so everybody will revert to the original will. Remember, the codicil comes to amend the will. So if it now shows that the amendment is faulty, it means that it's assumed it never existed, will revert to the initial will.
Okay, so we'll soon be wrapping up the segment. I just had a message here. Maybe some people are just trying to call. This one said, good morning. Please, I'm just trying to find out, how about in a situation where a father did not write a will and the children wants to share the property? I think I've asked that. But I'm sure the person is just joining us. Maybe you can just rephrase the question. And the children wants the property to be shared. What will help them to share? Can they share it from the family circle or involve extended family members? He's trying to ask the legal backing for
where there is no will.
Where there is no will.
Yeah, well, now where there is no will, like we mentioned earlier on, the estate will be shared according to the provisions of the state law, which more often than not spell out how it should go. The surviving spouse, the children, the parents of the deceased, the siblings of the deceased, that's how it goes. If there is a surviving spouse, for instance, Mr. Akpan dies, his wife survives. According to the law, the wife inherits everything belonging to Mr. Akpan. It will now be her place, now after inheriting everything from Mr. Akpan, to now say, okay, yes, I'm the wife, but Mr. Akpan has 7 children. 4 are from me, 3 are from somebody else. Okay, it's now in her place, if she has a kind heart, to say, okay, children of Mr. Akpan, come around. Let us share Mr. Akpan's property so that all of you can benefit from your father's estate. But that's free willingly. There is no law that compels her to share the property to the children. Okay. But she might want to give them, especially when those children are her own children. But then she might give them and say, okay, Mr. Akpan had 3 other children that are not from me. Let me also be a kind-hearted mother. 3 other children, come, take your own share of your father's property. Okay.
All right, thank you for coming. We'll have some other issues that has to do with a will, but I would love us to treat that differently so that we have enough time. Because we have witnesses, we have executors and all that. But today we're just talking about the will itself and what makes a will valid and invalid. So at this point, in summary, let's just get this straight. What makes a will valid and what makes it invalid?
Now, a will is valid when it meets all the requirements of law for making.
What are those requirements?
Number 1, like I mentioned already, that's quick recap. the person making the will must have testamentary capacity. Okay, he must be able to make a will. A will is like any other document, just like someone going for an exam. If he doesn't have the right mental state, he cannot read and pass an exam. So he must have the mental capacity to execute that document. Number two is that he must have a clear intent to make a will. I cannot go to an exam now, a physics exam, and I'm reading for chemistry, and I go there and I'm expecting to write chemistry, only to go and see physics. I failed. Okay, so while he's going to make a will, he must have that intention that I am going to make a will. This is what I'm here for. Okay, another one is that he must have credible witnesses to witness to what he's doing. Another one is that the will must be in writing. It's not enough to just say and talk, because as we have proven over time, a man says ABC to the next person. The next person relates it to the next person, will say BCD. Another person goes and says something completely different, and the message becomes distorted over time. But when it's written down, that is a requirement of the law to make sure that nothing is changed and nothing is lost. There are several other ones, but these are the basic ones that amount to validity of a will.
Let's talk about the ones that makes it invalid.
It's very simple. It's like mathematics. This is a point in time where law can be like maths.
Yeah.
When all these things exist, it is valid. When any of them, all of them must exist together.
Okay.
For it to be valid. The moment one is missing, or two, or all of it, it becomes completely invalid.
Okay. Thank you very much, Barrister Clement Imo, for coming on the show. We look forward to having you. Oh, sorry, I forgot the Amebo Barrister. I was supposed to add that, right?
Yeah.
Okay, it skipped me.
No,
okay, now let's talk about the Amebo Barrister before we go. We just hear Amebo attached to your name. And when we look at Amebo in the content of what we know, Amebo is a gossiper. So are you a gossiper barrister?
Not exactly. Now, Amebo Barrister is a brand name, and it's my way of reaching out to the community, reaching out to everybody, educating people about basic things of law.
Okay.
So the ones we hear in the market, the things the market women need to hear, people in the motor park need to hear. For example, as a bus driver, a public bus driver, you should maybe buy your ticket, make sure you drive on the right side of the road. So it's just basically gist. Looking at the law in everyday gist. That is what Amebo Barrister is all about. Okay,
so gist. Is the gist that is Amebo that we know now? Amebo is gossiping now. Sometimes, we have already attributed gossiping to negative aspect. But sometimes we can gossip in a positive way. Maybe that's just a way of giving information to the public.
Yeah, the only idea of Amebo Barrister is we will not keep quiet. Amebo, no, they close mouth. You keep talking. Yeah. So Amebo Barrister will keep talking the law, making sure it reaches everybody's ear. Even if you close your ear, you go still make sure say you talk and make you hear.
Thank God we had an Amebo Barrister today in our show. We look forward to having you again to talk about this will and other things that are involved. Thank you for coming on the show.
Thank you very much. It's been an amazing experience. I look forward to another visit.
Thank you very much. That is it. Then this particular segment of the program, we are still doing Pathfinder on AKBC Television. Don't go anywhere. Another segment of the program will come your way after this time out.